Hello everyone, welcome to SD Linux YouTube channel. In this video, we will discuss about Sale under Transfer of Property Act 1882. Let us begin with the most basic and important question here. What do we actually mean by sale in property law? In simple words, sale means the transfer of ownership of property from one person to another person. This transfer takes place in exchange for a price, and that price must always be money. Here, the law uses the word ownership. And this word is extremely important. Ownership means full legal control over the property, not just physical possession. So, handing over keys alone does not amount to sale unless ownership is transferred. Once a valid sale takes place, the seller completely loses all his rights in that property. Later, he cannot claim ownership, possession, or any benefit from it thereafter. At the same time, the buyer becomes the absolute owner in the eyes of law. The consideration for sale must be money only. Exchange of property is not sale. If property is exchanged for another property, it is called exchange and it is not a sale. For example, if I sell my house to you for rupees 30 lakhs, ownership passes to you. Even if you take possession later, ownership legally shifts on completion of sale. This is because the intention of parties is to transfer ownership immediately. Such a transaction is recognized as a sale under Section 54 of Transfer of Property Act 1882. Now that we understand what is sale means, let us see what is required for a sale to be legally valid. So what I mean to say is essential elements of this sale. The law does not recognize every transaction as a sale unless certain essential elements are present. First, there must be two distinct parties involved in the transaction. One party must be the seller and the other must be the buyer. The same person cannot be both. Second, the transfer must be of ownership and not merely of possession. Giving property on a rent or license does not amount to sale because ownership does not pass. Third, there must be a price involved and that price must be lawful. The price may be paid immediately or promised to paid later or partly paid and partly promised. However, the consideration must always be money and nothing else. Fourth, the transaction must be voluntary and not forced or fraudulent. If consent is obtained by coercion, fraud or misrepresentation, the sale becomes invalid. Fifth, the both seller and buyer must be competent to contract under law. A minor or a person of unsound mind cannot validly sell property. Finally, all these elements must coexist for a valid sale. If even one essential element is missing, the transaction will not be recognized as a sale in law. Now let us look at sale versus agreement to sell. This is one of the most important distinctions in property law, and students often get confused over here. Sale and agreement to sell may look similar, but legally they are very different. In a sale, ownership of the property is transferred immediately from seller to buyer. The moment a valid sale is completed, the buyer becomes the owner in the eyes of law. In contrast, an agreement to sell does not transfer ownership at all. It only creates a promise that the sale will take place at a future date. So, under an agreement to sell, the seller continues to remain the owner. Another important difference lies in the nature of rights created. A sale creates a right in the rem, meaning a right enforceable against the whole world. Anyone who interferes with the buyer's ownership can be sued. On the other hand, an agreement to sell creates a right in personam. The right is enforceable only against the seller and not against third parties. For example, when you book a flat that is still under construction, it is usually an agreement to sell. Ownership passes only when the final sale deed is executed and registered. So always remember the golden line over here is that sale gives title, agreement gives only a right to sue. Now let us understand what exactly a sale deed is and why it is so important. A sale deed is the legal document which officially records the sale transaction. It is a document through which ownership of property is transferred in writing. In simple words, it is a documentary of proof that a sale has taken place. Once a sale deed is executed and registered, the buyer becomes the legal owner. The sale deed contains complete information of both seller and buyer. It also clearly describes the property that is being sold. The total sale consideration and mode of payment are mentioned in the deed. Because of this, courts treat the sale deed as conclusive proof of ownership. Banks rely on sale deeds before granting home loans or other advances. Government authorities also verify sale deeds for mutation and tax records. If a person does not have a registered sale deed, he cannot legally prove ownership. Oral claims or possession alone are not sufficient in the eyes of law. That is why registration of a sale deed is compulsory for immovable property. So always remember this practical rule. No sale deed means no legal ownership. Now let us understand what makes a sale deed legally valid. Law does not accept every document as a valid sale deed unless certain conditions are fulfilled. First, the both seller and the buyer must be competent persons in the eyes of law. This means they must be adults and of sound minded. Second, there must be a clear intention on the part of the seller to transfer ownership. Mere delivery of possession without intention to transfer ownership is not enough. Third, the property being sold must be clearly and accurately described. There should be no confusion regarding locations, boundaries, or extent of property. Fourth, the consideration must be lawful and a real. A sale without lawful consideration is not valid. Fifth, the consent of both parties must be free and genuine. Consent obtained by fraud, coercion, or misrepresentation makes the sale voidable. Finally, proper stamp duty must be paid and registration must be done. Without registration, the ownership does not pass. So, all these essentials together make a sale deed legally valid. Now, let us look at duties of the seller. The law places several duties on the seller in order to protect the buyer. The first duty of the seller is to disclose all material defects in the property. Material defects including legal disputes, encumbrances, or physical defects. The seller must not hide any fact which may affect the value or enjoyment of property. Secondly, the seller must produce all title deeds for inspection by the buyer. This helps the buyer verify whether all the seller has clear ownership. Thirdly, the seller must answer all relevant questions truthfully. Any false statement by the seller may amount to fraud. The seller is also duty bound to execute a proper conveyance deed. Execution means signing the sale deed and completing legal formalities. Further, the seller must take reasonable care of the property till delivery. After completion of sale, the seller must deliver possession to the buyer. If the seller fails in any of these duties, he is legally liable. Thus, Section 55 ensures honesty and transparency from the seller. At the same time, the law also protects the interest of the seller. The seller has the right to receive the agreed sale consideration, means money. If the buyer fails to pay the full price or money, the seller can demand payment. The seller is also entitled to interest on unpaid sale consideration. This prevents buyers from unnecessarily delaying payment. Further, the seller has a statutory charge on the property of unpaid price. This means the seller has a security interest till payment is made. Because of this right, seller can approach the court if payment is withheld. The seller may also refuse to deliver possession until full payment is received. This right ensures that seller is not cheated. However, once the price is paid, the seller must deliver possession. The seller cannot retain possession after payment. Thus, the law balances the rights of seller and buyer. Neither party is balanced at an unfair disadvantage. Now let's look at duties of buyer. Buyer is not only given rights, he also has duties under the law. The foremost duty of the buyer is to pay the purchase price as agreed. Payment must be made according to the terms of the sale deed. The buyer must also disclose any fact which increases the value of the property. For example, if buyer knows about future development plans, he must disclose it. After ownership passes, the buyer bears the risk of loss or damage. If the property is damaged after sale, seller is not responsible. The buyer must also pay public charges and taxes after the sale. This includes property tax, water tax, and other duties. Failure to pay such charges may result in penalties. Buyer must also take possession responsibly. You should not misuse or illegally alter the possession. Thus, law expects the buyer to act honestly and responsibly. These duties maintain fairness in property transactions. Now let's look at rights of buyer. Once a valid sale is completed, the buyer gets strong legal rights. The buyer has the right to all benefits attached to the property. This includes easement, profit, and other advantages. He also has a right to peacefully possession and enjoyment. The seller cannot interfere with the property after ownership passes. Buyer has the right to make improvements in good faith. Any improvement made by the buyer legally belongs to him. The buyer also has the right to receive all title documents from the seller. These documents are necessary to prove ownership in future. If the seller withholds document, buyer can take legal action. Buyer's ownership is protected against the whole hold. Any interference can be challenged in court. Thus, buyer become absolute owner after the sale. Section 55 strongly protects buyer ownership rights. Now let's look at structure of sale deed. Sale deed is properly drafted. Drafting of a sale deed is not random. It follows a logical structure. It begins with the title of the deed and the date of the execution. Next, the full details of the seller and buyer are mentioned. After that come to the recitals, which explains how the seller acquired the property. Recitals are very important because they show the chain of title. Then the property description clause is drafted in detail. This includes boundaries, measures, and location. After that, the consideration clause is written. It means the total price and mode of the payment. The transfer clause clearly transfers ownership to the buyer. Possession clause states when possession is handed over. Indemnity clause protects buyer from future claims. Finally, execution and witness clause complete the deed. Agreement to sell is a preliminary arrangement between parties. It is only a promise that the sale will take place in future. Ownership does not pass under an agreement to sell. The seller continues to remain the owner of the property. This agreement mentions advance amount paid by the buyer. It also mentions the balance amount and time for the payment. A specific date is fixed for execution of the sale deed. Conditions to be fulfilled before sale are also mentioned. If any party breaches the agreement, legal remedies are available. The usual remedy is a suit for specific performance. Throughout the suit, court can compel execution of sale deed. Agreement to sell protects both parties before final sale. It avoids uncertainty and misunderstanding. Thus, it acts as safeguard in property transactions. Now, let's look at common mistakes and conclude the session. Most of most property disputes arise not because of law, but because of the mistakes that what usually do. One of the most common mistake is unclear of property description. Vague boundaries often lead to long-term litigation. Improper stamp duty payment is another serious error. Non-registration of sale deed is extremely dangerous. Without registration, ownership is not legally recognized. Missing possession clause creates confusion regarding control of property. Wrong or incomplete party details can invalidate the sale. Failure to verify title documents lead to fraud cases. Poor drafting is the root cause of more property disputes. Always remember that property law is document driven. Clear drafting avoids litigation and loss of money. Understanding sale under TPA, that is Transfer of Property Act, builds strong foundation. Once a sale is clear, property law becomes easy and scoring. If you found this video helpful, please subscribe to our YouTube channel and share it, like and share with your fellow friends. Thank you for watching.